time, ma'am? Reserve some
Yes,
rebuttal?
4 minutes.
4 minutes? Thank you.
This case presents two major issues. The first one is double jeopardy, which I don't believe that the state argues that it was violated in this case when Mr. Rollins was retried on the charges for a rape of a child that he had been previously acquitted. The question arises then what the court's authority is aside to order a new trial. Does the court have any other authority to remedy the violation? Our position is that the
Ms.
court...
Trant, may I, before you get
Sure.
fired up and really get going, can you tell this court how this happened?
I believe it wasn't, I don't believe it was on purpose on the part of the state. Definitely it was an oversight on our part.
I'm sorry, did you say it was not intentional on the defense part?
Oh, it was not intentional on the part of the state. It was just oversight of all the parties.
Including the defendant and the defendant's attorneys?
Yes.
So you're saying it was malpractice on your behalf?
Well, we did notice that. We did notice the double jeopardy issue before the sentencing.
Before sentencing, but before trial the second time, did you notice it?
No.
And it wasn't an intentional move on the part of the defense to allow this defendant to be tried again for something he had been acquitted of?
No, it was not intentional.
So hasn't the issue been waived?
No.
Well, we have something called Rule 12 that requires pretrial motions, especially ones that involve the initiation of a prosecution, to be raised prior to trial, or they're considered waived. And in this case, we're talking about double jeopardy, and we're talking about the branch of double jeopardy that doesn't allow multiple trials. And so instead of filing a motion to dismiss, you just going to have the trial and see what happens?
We didn't notice it until the sentencing hearing.
Ma'am, could you pull that microphone in front of
Sure.
you, please, a little bit? I'm having a little trouble. You
Sure.
did not notice it until sentencing. I think that's what
Before
you
the
said.
sentencing, yes.
And you represented him at the first trial.
I did.
And were fully aware that the jury acquitted him, at least of the major charge.
Yes.
And you allowed your client to be put to trial again for that same offense.
It was unintentional, yes.
It was what?
It was unintentional.
Okay. And then as to the other counts, the aggravated sexual batteries, what happened? Was the jury deadlocked on those two in the first trial?
Yes, the jury was deadlocked, yes.
And does the record tell us what the jury was deadlocked on, which particular offense?
Aggravated sexual battery, both counts.
So the jury was hung on both counts of aggravated sexual battery, the first trial.
Yes.
And also hung on the rape of a child.
Acquitted of rape of a child.
Excuse me, acquitted. But the record indicates they were hung then on what offense?
Aggravated sexual battery. There were 3 charges, rape of a child and 2 counts of aggravated sexual battery.
But as to count 1, where the rape of a child, where was the jury hung? What charge were they hung on?
The jury, it was acquitted.
On altogether, not guilty of anything,
Not
aggravated
guilty
sexual
on-
battery, attempted rape, or any lesser included offense?
Not guilty on the rape of a child and hang on aggravated sexual battery.
For count 1 as well?
Count 1 was aggravated rape of a child.
Yes, ma'am.
He was acquitted. Count 2 was aggravated sexual battery. It was a hung jury. And count 3 was aggravated sexual battery, hang jury.
Well, what he's asking is, on count 1, were there lesser included offenses charged, and did the judge inquire as to where in the hierarchy of the lesser included offenses
No.
they were stuck on?
No, they did not. There was no inquiry made.
Because when I charge a jury, they usually come back with a verdict, and it would we find the defendant not guilty of count one, which would include the charged offense and all the lesser included offenses. But I'm just trying to figure out where in the hierarchy the failure to agree was at.
There was no instruction to that effect.
Well, more importantly, what does this record show about what happened in the first trial with regard to the jury instructions and the verdict of the jury?
The jury instructions for the first count was just a rape of a child.
Is that in the record for this
Yes.
case? I guess going back to Judge Ward's questions, his initial question about, you were the only person in this room who was present at both trials, correct?
No, the prosecutor also was.
I'm talking about as we sit here
Yes, in
today.
this room,
As we
yes,
sit
that's
here
correct.
today.
That's
So
correct.
tell us, or tell me, I'm just curious, was it the same prosecutor on the first trial as it was the second trial?
Yes, sir.
And the only different persons I recall, the trial judge changed.
The trial
It was
judge.
a different judge.
Yes.
But other than the judge, all the parties and lawyers are the same individuals. And nobody mentioned at trial 2 that this defendant was acquitted of count 1.
Just prior to the sentencing hearing, yes. No, not during
Prior to the
trial.
sentencing hearing, I understand. But at trial,
No.
that's shocking. But that's just me.
But now you want relief from the fact that he had to go through a second trial.
Yes.
Go ahead with your argument.
So the question becomes what the judge authority is when such situation occurs. We argue that we are entitled to a new trial. In this case, the trial judge set aside the verdict for the conviction of rape of a child and convicted my client in the lesser included offense, which is attempted rape of a child. However, the Rule 33 of the Rules of Criminal Procedure limit the authority of the trial court as to what he can do or he cannot do. It's either accept the verdict of the jury as a 13th juror or disagree and orders a new trial.
But as I understand your statements here today, in count 1, your client was found not guilty of anything. Is that right? The first trial?
Yes.
Not guilty of
anything.
any offense? Okay. And that's the count that the judge modified at the second trial to attempted rape?
Yes. Yes. That's one of the issues. The second issue is admission of evidence of prior bad acts. The evidence that was introduced at trial was of acts that were so similar, so plainly similar to the offense that was litigated at trial that the prejudice occurred to, in our opinion, by introduction of that evidence.
And that evidence, as I recall, was that several years earlier, your client had exposed himself to this victim?
No, that evidence was the testimony of the victim when he was 3 or 4 years old. Allegedly, he went into a room with my client, and my client told him to take his pants down.
Okay.
And he tried to touch his penis.
Okay.
And the trial court ruled that the evidence was admissible as relevant to the issue of intent to achieving sexual arousal or gratification, which he ruled that it was an element of the offense of rape of a child or aggravated sexual battery, which was not. Achieving sexual arousal or gratification is not an element of rape of a child nor of aggravated sexual battery. Therefore, the the admission of the evidence was erroneous. For that reason, we are asking for relief.
Thank you, ma'am. Any questions? General Douglas? I know that the state normally begins its argument with the trial court, or this court should approve and so we'll get that. I want to ask you a question. If you want to go ahead and say what you're supposed to say first, that's fine, and then I've got a question.
May it please the court, your honors. Davey Douglas on behalf of the state, happy to answer any questions.
Oh, okay. Taking a different path. Was counsel for the appellant correct in that her client was acquitted of everything in count one at the first trial?
That was not my reading of the record.
Mine either.
I believe that the jury acquitted the defendant only of the charge of rape of a child. It was hung on all of the remaining lesser included offenses.
Beginning with?
The record doesn't specify. I think the reasonable assumption is attempted rape of a child.
Can we make that kind of assumption?
What the court can do is simply look at the record that the defendant has prepared, and the only transcript evidence that we have from the first trial is a small excerpt from the end of the first proceeding where the trial court says that it will enter a judgment of acquittal for rape of a child, and it will declare a mistrial for, and I believe the language is the remaining lesser included offenses.
But we do not know what those were with the record that we have.
With the record that we have, we don't know for certain.
Do we even have a transcript of the jury returning into court and finding the defendant not guilty?
We have an excerpt of that transcript. We do have the jury foreperson, I believe, telling the court they found the defendant not guilty of rape of a child. And then the trial court sends the foreman and the rest of the jury back to continue their deliberations.
On counts 2 and 3?
On count 1, I believe,
okay.
the lesser included,
Okay.
again, just going off of the short excerpt that we have from that trial proceeding. And it did also send the jury back to continue deliberating on counts 2 and 3.
Well, do we have the instructions from the first trial?
No, Your Honor, I do not believe
And
that
so
we do.
the traditional instructions that when you reach a verdict of not guilty on this, you'll automatically proceed to the next lesser included offense. This jury didn't do that. They just came back in the courtroom and said, we found him not guilty of rape of a child, and didn't do what the instructions tell him to do?
So what we do have is the foreperson coming back and saying that the jury was deadlocked. That's what the foreperson said. And then the trial court said essentially what you just pointed out, Judge Ward, that, okay, well, the way this works is I need to figure out which offense you're deadlocked on. And that's where the foreperson said rape of a child. Or, excuse me, the foreperson said that the jury had acquitted the defendant of rape of a child. And then that's when the trial court sent the jury back for further deliberations, I believe on the lesser includeds of rape of a child, and then counts 2 and 3, the aggravated sexual battery.
Does the record include any type of transcript of what happened when they came back the second time? Is that in the record?
That is part of the record, Your Honor.
I'm not talking about the second trial. I'm going second time, first trial.
No, yes, Your Honor. That is part of the record. That excerpt includes when the foreperson, the jury, came back a second time, believe announced that they were deadlocked on the lesser includeds of count 1, rape of a child, is how they identified the count. I don't believe that they specifically identified the lesser included on which they were hung, but the trial court then announced that it was going to enter judgment of acquittal for rape of a child, declare a mistrial for the lesser includeds, and that it would also declare a mistrial for aggravated sexual battery in count 2 and in count 3.
Okay, so there was then an order, at least as to count 1, or some type of judgment went down that says not guilty of rape of a child.
Yes.
How does the state allow that then to go to trial again? Can you explain that?
I certainly understand the concern and the question, Your Honor.
With the same prosecutor, as I understand. Is that correct?
I believe one of the prosecutors was the same. There was a new prosecutor on the second trial, and what we have to go on is sort of the transcript of the sentencing hearing, where it kind of came to light that this was just, unfortunately, an oversight by both sides here. I want to be candid about that. This was not, I think, how either party had intended this to proceed.
Well, does that, I know your brief would take a different position, but how could that not be prejudicial to a second jury to try a defendant for that charge, rape of a child, and not just be where he was acquitted, just not hung, but outright not guilty of that, and that testimony be presented to a second jury and not be so prejudicial that all we can do is send it back?
It wouldn't be prejudicial, Your Honor, for the reasons set forth in the U.S. Supreme Court case of Morris versus Matthews, where it was a very similar situation. The defendant, Mr. Matthews, went to trial on a jeopardy-barred offense. He should have never gone to trial on aggravated murder. And the Ohio Appellate Court later found that it violated double jeopardy for him to go to that trial and reduce the conviction to murder. And what the U.S. Supreme Court held is there was no prejudice because the jury, by convicting Matthews of aggravated murder, necessarily found all of the elements for murder. And that's exactly what we have here.
And they apparently also found all the elements for robbing a bank, I believe, that made it aggravated murder, correct?
Yes, Your Honor.
And so I guess just in the previous argument, or maybe it was Mr. Harwell's argument, talked about jury psychology. I think there's a difference than robbing a bank and raping a child and the prejudicial effect that would have on a juror. Do you agree?
Not necessarily,
Okay.
Your Honor. This is also an issue where we really don't have much Tennessee case law on it, and I would have certainly agreed that the offense of murder and robbing a bank is different from rape of a child, but the principle from Morris is the same as applied here, that the jury necessarily found all of the elements of attempted rape of a child, which would have been the non-jeopardy barred charge, when they convicted him of the jeopardy barred charge of rape of a child. And that's,
Well, I was going to ask, Morris is different too, in that in Morris, did the jury not reach the same verdict in both trials?
In Morris, it was a guilty plea for the robbery offense, and then he later confessed to the murder.
Okay.
And that led to the indictment for aggravated murder, and the jury did convict him of aggravated murder.
Okay.
But again,
and I get for what your argument, I believe, Mr. Douglas, that for the proposition that a sentencing judge can take a look at the evidence and reduce it to a lesser included. I think you're probably correct about that. I don't think I've ever been confronted with that, but I can see how, if the evidence supports all the elements, how a sentencing court could do that. Again, though, it's troubling to me, the prejudicial piece of particularly this type of an allegation that the defendant was found not guilty of by 12 people.
and I certainly understand the concern, Your Honor, and I think a good sort of contrast is Price versus Georgia, a case that the defendant cites in his brief and one that the state distinguishes in its brief. In Price versus Georgia, the defendant was charged with murder, but he was convicted of voluntary manslaughter. And then he went to trial after challenging his voluntary manslaughter conviction. That was remanded for a new trial, but he went to trial again for the offense of murder, and the jury again convicted him of voluntary manslaughter. And in Price, the Supreme Court, it couldn't hold that there was no prejudice because of the gap between the charged offense and the lesser included that the jury returned a verdict on. The court was concerned that the presence of the greater charge might have caused the jury to, rather than deliberate about the defendant's innocence on the charge of voluntary manslaughter, simply settled on that conviction offense as kind of a compromised verdict. That's not what we have here. We don't have the jury convicting the defendant of a lesser included offense. It convicted him of the greater, and in doing so necessarily found each one of the elements of the lesser included offense of attempted rape of a child would have been proven. And so, again, I think that if this is a case where the jury would have convicted him on a lesser included offense, the prejudice argument is much stronger. But this case, since they convicted him of the greater, it's really just like Morris versus Matthews. It's also like State versus Martin, an Arizona case that the state cites in its brief. And the conviction of the greater offense here meant that the jury necessarily found all the elements of the lesser. And the trial court's remedy here to enter a judgment of conviction for attempted rape of a child was the proper remedy. And I would urge this court not to exalt form over substance in reviewing the trial court's ruling. There is a reference to the 13th juror, and there's a reference to setting aside the verdict. But what the transcript makes clear is the court was not trying to disagree with the jury about the weight of the evidence and set aside the verdict as Rule 33D permits. What it was doing was exactly what the trial court did in State versus Hill. It was simply entering a judgment that differed from the verdict. It was trying to cure the double jeopardy violation here. It was not saying that it disagreed with the jury about the weight. And even if it would sort of makes the trial court intent a little more clear, the advisory commission comments to Rule 33 say that if a trial court sets aside a verdict under Rule 33D, double jeopardy does not bar a mistrial of that offense. Here, it's very clear that the trial court was, unfortunately, trying to cure a double jeopardy violation. So it was not attempting to simply disagree with the weight of the evidence. It was just trying to fix an error, much like this court and our Supreme Court will do if they conclude that the evidence is insufficient to sustain a conviction on appeal. They will, rather than remand for a new trial, remand for entry of judgment of conviction for the next lesser included offense. And that is essentially what the trial court did here. And that was a proper exercise of its authority. And I would like to address the 404B issue as well. The trial court here did not abuse its discretion by admitting evidence of the defendant's prior bad act. The evidence was really relevant to explain the victim's delay in disclosing the abuse and to demonstrate that the victim was telling the truth when he disclosed the abuse. This first incident happened when the victim was 3 or 4, but he continues to remain in this traumatic, chaotic environment. Several years later, we have the conduct that leads to the charged offenses that resulted in the defendant's conviction, but the victim still remains in the defendant's orbit for several more years until he's placed into foster care. And what the victim himself explained was that based on the fact that nobody really seemed to protect him from the defendant, he didn't feel comfortable disclosing the abuse. It only was after he had been with his foster family for several years that he felt safe enough that he could start to disclose the abuse. And what several of the forensic interviewers who interviewed him testified to was that that's consistent with a child making disclosures like this. It's a process. It's not something that happens all at once. And what was also significant about the timing of the victim's disclosure, they occurred before the incident with his stepfather. And a big part of the defense here was that the victim was simply embarrassed about that incident where his stepfather found him, and that he made up these allegations about the defendant to sort of deflect from his own embarrassment. But he's disclosing this incident that occurred when he's 3 or 4 before the incident with his stepfather. So it goes to show that he's not simply fabricating or manufacturing these allegations to avoid something with his stepfather. He's actually telling the truth here. And that's where, again, this was highly relevant to give the jury a full picture, a full understanding of the timeline of the victim's traumatic and extensive experience with the defendant. And after the trial court complied with all the requirements of Rule 404B, it held a jury out hearing, it found that there was a material issue, and it implicitly found clear and convincing evidence of the prior bad act when it credited the victim's testimony about the act. And then it found that the prejudicial value, that the probative value was not outweighed by the prejudicial value. So the court here properly applied 404B, and it did not abuse its discretion.
Well, respectfully, Mr. Douglas, I don't think 404B is the state's major issue in this case. And I want to get back to the prejudice piece of it. I want to make sure you put your best foot forward and you've made the argument you want to make. I don't want to interrupt you on it, but I do wonder, was there proof at the second trial of penetration of this victim?
Yes, Your Honor, there was. It was the testimony of the victim.
And a previous jury had said not guilty of that.
That's correct, Your Honor.
Would you agree with me that that was prejudicial for the second jury to hear?
No, Your Honor, I would push back on that,
Okay.
just because our state Supreme Court has said that you can still prove the offense of attempt by showing a completed offense, and that if someone is charged with only attempt, the state is not limited to showing only proof of the attempt. And it also is a little, it's harder to assess prejudice without a full transcript of what happened in the first trial, which is not part of the record. We only have a very small portion that was introduced as an exhibit at the sentencing hearing.
Well, for just sake of our discussion here, let's just assume the record is clear, that the jury said we found the defendant, first jury, not guilty of rape of a child, and we cannot reach an agreement on attempted rape. If we had that, then at the second trial, you believe the case law would support the state then introducing evidence of an actual penetration?
I believe it would, Your Honor, and that comes from State versus Thorpe, which is a 2015 Tennessee Supreme Court case where the Supreme Court says that the state is not limited to only proving attempt to sustain a conviction for an attempt. It can go further. And so I think that it would have been permitted here for the state to introduce the same evidence of penetration. I don't think that the state would have had to tell the victim to only describe what happened up to a certain point. The victim would certainly still be permitted to testify about everything, and the jury would be able to consider that as evidence of attempt. And so that's why, again, I don't think that we have the prejudice here that requires the dismissal of the judgment of conviction for attempted rape of a child, because the jury, it considered all the elements of the greater offense, and it found the defendant guilty. So again, it necessarily would have found that the jury, that the defendant satisfied all of the elements of the lesser included offense of attempt. And Judge Easter, I certainly understand the concern about prejudice and just the posture of this case. I certainly understand that. And that's where, again, I would sort of point this court back to Morris versus Matthews, where the Supreme Court there recognized the gravity of the situation it was confronting, and that it specifically said, this is not a harmless error analysis. This is an error analysis. And it went on to hold that it would be incongruous to order a third trial for a double jeopardy violation when the more appropriate remedy was the entry of judgment of conviction for a lesser included offense, which is what the trial court did here. The trial court here, identified the problem and imposed a remedy that our United States Supreme Court has endorsed. And unless there are, I see my time is running out.
Okay, well, just one last question, I guess, that do you feel like the evidence of rape of a child in trial number 2 had prejudicial effect on their aggravated sexual battery convictions in counts 2 and 3 as well?
I don't think that it did, Your Honor, simply because, again, the jury convicted him of that greater charged offense. And what I believe it's Maryland versus Benton has held, and that was a U.S. Supreme Court case, is that when the jury convicts of the greater offense that is barred by jeopardy, it really diminishes the risk of any prejudice for other offenses that were connected, because it shows that the jury considered all of the proof and that by reaching the conviction on the greater offense, it wasn't somehow influenced, like say the jury might have been in Price versus Georgia.
Thank you, Mr. Douglas.
Thank you. We'd ask this court to affirm.
Ms. Trent,
Yes, I waive the rebuttal.
you're waiving any rebuttal? No rebuttal? Okay. Thank you, ma'am.
Thank you.
Please call the next case, Madam Clerk.